Part 1 of Day 1 of Monica's Bad Court Thingy. Monica had a lot of supporters there to watch her, about 50, 60 odd, I would guess. I noticed some familiar faces, her mum, Rukshan, Nick Patterson, and was surprised to see Peter Little. We all waited outside courtroom 1.6 for the court staff to let us inside. There was a round of applause from supporters when Monica arrived. The courtroom only held 39 people. So many were forced to wait outside. Luckily, I managed to get a seat. The legal issues. Monica is suing the state of Victoria for the tort of false imprisonment for the 3 times she was arrested during COVID lockdowns on 31st October 2020. This means the court needs to be satisfied that the 3 arrests were unlawful. The onus is on state of Victoria to prove the arrests were lawful. They are relying on Section 458 of the Crimes Act, which says that police can arrest someone without warrant, as was the case here, if they, A, find that person committing an offense, and B, reasonably believe the arrest is necessary for certain prescribed purposes, e.g., to reserve public order, prevent the continuation of the offense, etc. Quote, finds committing an offense is defined in Section 462 of the Crimes Act. Victoria Police do not need to prove that they found Monica committing an offense or that she committed the offense, just that the arresting officer, quote, believed on reasonable grounds that Monica committed the offense. Monica was arrested for various breaches of COVID lockdown rules without lawful excuse. So the state of Victoria will need to prove that the arresting officers had reasonable grounds to believe that Monica was breaching COVID rules without lawful excuse. Opening submissions. After some discussions on preliminary points of evidence and witnesses, as well as the legal issues in the trial, Justice Tran invited Monica to commence her opening submissions.
Do I have to open?
She asked. Monica wasn't being difficult. She was genuinely curious whether it was a requirement that she do so. Justice Tran explained to her that the plaintiff, being the one that commences the proceedings, goes first. Monica commenced her opening submissions. She reminded the court that she wasn't really experienced in, court stuff.
Extent of my experience is watching YouTube videos. Stop me if I'm going down too many holes.
My favorite.
Your Honor, if I've convinced you, then you can stop me. I don't want to be wasting your time making arguments if I've already convinced you I'm right.
Now, the purpose of opening submissions is to outline to the court what the legal and factual issues are, and to outline the case you are going to present. Monica didn't really do this. That aside, she spoke well. She was confident and clear, and didn't seem nervous at all. You could tell she had practiced, well, the first half of her speech anyway. I will get to this. She spent much of the first half of her submissions describing her journalism, arguing that even though she was an independent journalist, she was still a journalist, and that was a lawful excuse for her to be attending a protest during COVID lockdowns. She spoke at length about her work as a journalist, describing the stories she covered and videos she'd made before and during the early stages of COVID. She spoke passionately about the day of arrests, and seemed to think that police should only arrest people they perceived to be a threat.
No one seeing me in my long skirt and my long flowing blonde hair would have seen me as a threat. When I was arrested, I didn't swear once. Why? My crime was live streaming the side of the story they didn't want me to tell.
Monica was reading off her prepared speech, and at times she became quite passionate, speaking very quickly, reading out the words on the page without processing them beforehand.
Oh, that was a note to myself. I wasn't meant to read that out loud.
At one point, the judge interrupted her and reminded her that the case is not about whether Monica committed the offenses. The case is about whether the arresting officer had reasonable grounds to believe Monica committed an offense. I think that threw Monica a bit because she clearly wants the court to find that she's a real journalist, a finding the court doesn't have to make. Monica mentioned that one of the arresting officers had described her as mentally ill.
If he thought I was mentally ill, he could have treated me better.
Monica then moved on to summarizing the law and legal principles relevant to her case. At this point, Monica had been speaking for a good 30 minutes or so, I think. It felt that long anyway. This is when the quality of her opening submissions started to deteriorate. I suspect she'd practiced the first half of her submissions, but not the second half. Perhaps she was also tired after speaking for so long. It was also apparent that she'd written the first half of her submissions, but the second half were a copy-paste of legal research she'd done online. She summarized various laws that weren't relevant to her case, such as negligence, assault, battery, breach of statutory duty. She summarized the legal definition of, quote, reasonable belief, then paused after she'd only read out the first half of the definition.
Oh, I didn't paste the rest. Never mind.
As she went on, it felt like Monica was reading her submissions out loud to herself for the first time. She'd start quoting one law, then realize she didn't want to say that anymore.
Doesn't matter. I'm not going to say that. I won't read that whole bit.
It was quite odd. A stream of Monica's consciousness as she read her submissions out loud for the first time. Finally, she gets ready to conclude her opening submissions.
A call to action. I've got to have a call to action.
She said that she isn't doing this case for the money, though she said she deserves money. She said she wants recognition that she was unlawfully treated. Monica said she suffered no damage. She said she's a strong person and wasn't affected by the arrests. She said the only damage she suffered is that she was embarrassed. She was crying, and no one cared. Monica concludes her opening submissions. Counsel for the state of Victoria's opening submissions are rather brief. She points out that Monica has made allegations in her opening submissions which aren't covered in her statement of claim, e.g., alleging that the police's actions constituted assault and battery, negligence, and a breach of their statutory duties. This is not permitted, and Monica needs to confine her case to the tort of false imprisonment, as that is what she has pleaded in her statement of claim. The state of Victoria says that the arresting officers had a reasonable belief that Monica attended Flagstaff Gardens the day of the arrest as a protester, not to report on the event. She says Victoria Police formed this view based on Monica's online activities before the day of the arrest and her questions to officers on the day. She flags evidence will be led of Monica's online activities prior to the day of the arrest. Counsel for the state of Victoria said the question of whether Monica is a journalist is only relevant to the extent to which police had reasonable belief that Monica was committing an offense. It's otherwise not relevant. Evidence in chief. Following conclusion of the opening submissions, it was now time for Monica to take the stand to give evidence. Given Monica was self-represented, this was not going to be straightforward. She is now wearing two hats: witness and also advocate for herself. Advocates can't give evidence. That's the role of a witness. Witnesses can't make submissions. They can only give evidence about things they've actually experienced or observed. These lines became increasingly blurred during the course of Monica's evidence. I will return to this. Upon taking the stand, Monica makes very clear that
my journalism is a big part of the case.
She said,
I'm going to spend quite a lot of time proving I'm a journalist.
Now, that wasn't an understatement. As part of preparing for her case, Monica learned that if she asserts something as fact, she needs proof to support it, and that needs to be tendered into evidence. The next hour or so involved Monica tendering all the evidence that she said proved she was doing real journalism. Screenshots of the number of subscribers on her Facebook and YouTube pages, screenshots showing how many people had viewed her videos, screenshots of her websites showing the kinds of videos she made, copies of videos showing her interviewing MPs as proof of her work as a journalist. It's difficult to describe, but picture Monica sitting in front of a computer in a witness stand, showing screenshot after screenshot and saying,
I request to tender document blah blah as evidence.
In Monica's defense, she was just trying to follow court procedure. No one had told her that she could have tendered most of these screenshots as evidence by simply including them in an affidavit. That would have saved us all sitting there while she essentially did this in real time.
I'm quite sensible and rational, although I don't have any evidence to tender for that.
She said at one stage. Haha. She also showed videos of herself at a protest a few weeks prior to the date of the arrest. She was there filming the event and interviewing attendees. Monica claimed she attended as a journalist, not a protester, but acknowledged,
After watching this clip, some people may think I wasn't a very good journalist.
other evidence of Monica working as a journalist included the fact she paid someone to basically carry her belongings for her so she didn't have to wear a backpack.
Backpacks aren't flattering, okay?
Once the evidence of her journalism was tendered into evidence, we then watched a video compilation Monica made of police body cam footage from the day of the arrest. I assumed we'd be watching the entire video of the police body cam footage without interruption, but every 30 seconds, Monica asked the court to pause the video so she could add commentary or make submissions in favor of her case, such as,
Can you pause, please? Okay, so here you have the police questioning me about X. Now as you can see, the police haven't asked me about such and such. Okay, pause here. The police are questioning my dad about his exemption. The police were unreasonable here because blah, blah, blah. What you can't see in this footage is when police asked Morgan about blah, blah, blah. As you can see from this footage, I was super polite.
Objection, Your Honor.
State of Victoria's barrister makes an objection, saying that whilst Monica may be self-represented, she's technically a witness at the moment, so can't be making submissions advocating for her case or making statements about matters she hasn't personally experienced or personally felt. Monica continues with her evidence. She now starts adding the words,
In my personal experience, I personally felt
in front of nearly every sentence, thinking that as long as she does that, she can say whatever she wants. Because that makes whatever she's about to say her experience or her personal feeling. In Monica's defense, she was genuinely trying to comply here. It was just funny to me that she thought the problem was the way she was phrasing her statements, and this could be corrected with a change in wording. After watching the police body cam footage, Monica, who's still giving evidence, sought to tender the letter of apology from Victoria Police to Avi Yemeni. You will recall that Avi Yemeni sued Victoria Police for false imprisonment in 2021. Victoria Police agreed to settle the case, issuing Avi with a letter apologizing for the hurt and embarrassment he'd suffered from being arrested. Victoria Police objected to this letter being tendered into evidence on the grounds it wasn't relevant to a fact in issue in Monica's case.
This letter isn't relevant to the question of whether the arresting officers in this case had reasonable grounds to believe that Ms. Smit committed an offence.
Monica said the letter was relevant, noting it's
not case law, but it's the closest thing to case law I have.
The court denied Monica's request to tender Avi's letter into evidence on grounds of lack of relevance. Case continues tomorrow with Monica continuing her evidence in chief. She will then be cross-examined by the defense. I thought important to make clear that whilst this case appears on its face to be completely devoid of merit, at all times during the hearing today, Monica has shown respect to the judge, the court, and the defendants. Today, that is.